Hello, good evening, everybody. I believe that you all could hear us. I believe the speakers are all ready. Today promised to be a very interesting discussion that we're going to have, which is about third-party funding in an arbitration. As the name suggests, it talks about funding in an arbitration by a third party who is not a party to the arbitration proceeding, much like an investor who is investing in that arbitration proceedings. So much like investments, there will be issues as to whether this should be regulated or unregulated. Now, internationally, there is already a movement to regulate, of which we will hear from our speakers today. And locally also, there is an attempt at providing some framework for this third-party funding. Today, we are fortunate to have distinguished speakers. I will not do justice if I do not introduce them properly, although all of them said to me that they require no introduction because their name precedes their reputation. But I will still nevertheless introduce them. First, we have Madam Mankiranjit Kaur. Although the screen name is Kiran Singh, but it's actually Mankiranjit Kaur, Kiran Kaur. She is the legal advisor to the Ministry of Entrepreneur Cooperative Development of Malaysia, and she has been in the legal services for a very long time, for as long as I could remember. She has been a magistrate, she's been there, she's been that. She's much like the Rolling Stones, you know. She has actually rolled all over, and including as obviously an adjudicator. She is highly qualified, and more recently, she has completed her diploma in international commercial arbitration in the University of Oxford, and she is a fellow with CR. She is also an adjudicator. That is Madam Mankiranjit Kaur. The second speaker will be Ms. Janice Tay. Janice also requires no introduction. She is a highly acclaimed practitioner and also a counsel insofar as arbitration is concerned. She is the head of the International Arbitration and Construction and Engineering Practice and co-head of the Dispute Resolution Team and Wong and Partners. And this is a member firm of Baker McKenzie. And she is everything: arbitrator, mediator, adjudicator, and whatever hat that she can put and fill her head. And she has actually been recognized in all the reputable publication that list and grade councils, including Legal 500, Arbitration Power List, Legal 500, and others. She is also the president of the Society of Construction Law and a director of CR Malaysia. That is Janice. And last but not least, we've got Genwee Wong. He is also highly acclaimed. Younger practice according to Singapore Business Review under 40. That was in 2019. And he's been in practice for quite some time. He is from Baker McKenzie, Wong and Liao in Singapore. And he is the head honcho of the arbitration practice in Singapore. And he has also been similarly graded very well in the grading of lawyers. So you have it, a very experienced practitioners who will basically regale you today with third-party funding. So how we're gonna have this moderated is that we will basically have in the speaking way. So Ms. Kiran will start with introduction and also the amendment to the Arbitration Act in Malaysia, where I believe she was involved in the drafting process and is also in seeing it through in Parliament. She will take you through the Malaysian experience. Then it will be followed by Janice and Genvi with the international experience. Then what we will do is in the remaining time that we have, then if you have any questions, you can either do it through the chat box or if you're not shy enough, then you can always feel that question directly when we have the time. So without further ado, may I now invite Kiran to start the ball rolling. Kiran, over to you. Thank you.
Thank you very much, Dato. Thank you for the introduction. I'll always remember myself as a Rolling Stone from now on. Good evening, everyone. I am extremely glad to be sharing the screen with Dato and my fellow friends, Janice and Junvi, who have such impressive CVs. Okay, I will be speaking about a little bit about the introduction to third-party funding, just to give an idea about what we're going to be speaking about today. I will then proceed to speak a little bit about why Malaysia has decided to legislate third-party funding, and then perhaps go through, if we have the time, go through some of the pertinent provisions in the bill. Okay, when we talk about third-party funding, as Dato has mentioned, it's basically a third-party funder who is funding the costs of the arbitration in exchange, perhaps, for a share of the proceeds if the funded party is successful in the arbitral proceedings. So basically, the third party, the funder is investing in cases with strong prospects of success, where there is, after having looked through or studied the case, where there is, they feel there is financial returns in the particular case. So it's basically a gamble that they actually take. Okay, when we talk about third-party funding, it is always interrelated with this the concepts of maintenance and champerty. As we know, maintenance and champerty are basically where funding is given by a third party. So maintenance is by a third party with no gains or no interest in the outcome of the matter. Whereas champerty is a bit more, where it is very similar to third-party funding. And historically, both these maintenance and champerty concepts or principles have been considered a tort, and in some jurisdictions, it has been criminalized. In Malaysia, it's the same. We have Section 3 of the Civil Law Act, 1956, and we have the Legal Profession Act, Part 6, which prohibits funding by legal practitioners where they are involved in a case due to conflict of interest. So the issue of public policy comes into place as it is deemed that third-party funding goes against public policy. Goes against public policy. I would say that third-party funding took off internationally in somewhere around 2013, and Malaysia has followed suit after following nations like Hong Kong and its neighbor Singapore in legislating third-party funding. So what led to this, to the government's decision to legislate third-party funding was basically due to the Malaysia Sulu arbitration proceedings. That was a proceeding, that arbitration was funded by a third party, though not disclosed during the proceedings, never disclosed up to today. It was efforts were made to discover, and it was discovered eventually by the government that was the cause of it. So that is when the legal department in the Prime Minister's department decided that something had to be done to legalize third-party funding in this country so that it is better regulated. So that led to it being legislated. So last year it went to Parliament. The bill has been gazetted. It has obtained royal assent, but it has not come into force because there are steps that need to be taken before the law can actually come into place. All right. When we talk about third-party funding, there are mixed reactions. Some say it's good, some say it's not. Some view it, positively, and others do not. In this, when we were in Parliament and it was being debated, I remember the minister in the Prime Minister's department, Dato' Azalina, taking off by saying that third-party funding can benefit beyond financially, supporting, I'm quoting her, benefit beyond financially supporting meritorious claims for impecunious claimants. So it was another reason I could say is why third-party funding is being legislated now, is because it will help, it will help the vitality of the arbitration industry globally. So it has got its benefits. We will talk, I'm sure, as we go along, we will look at the potential abuses, etc. And that needs to be weighed with the interests of the parties. I will look at some of the pertinent areas in the bill. So that the bill, the third-party funding can be found in Part 3 of Chapter 2. And it is modeled much after, actually, a lot of it is modeled after the Hong Kong arbitration ordinance. So that's where we took our cue and looked to. We looked at Singapore as well, and so it's a bit of here and there, but generally or greatly, Hong Kong was the preferred jurisdiction we looked at. So when we look at the definition section, it's the usual, okay, it defines what who is a third-party funder, who is the funded party, and it discusses about what a third-party agreement is all about. Okay, what I can gather from it is that when we talk about third-party funding, it covers not just the arbitration period. It says arbitration, but it covers everything from prior to the arbitration proceedings itself, and it goes beyond. In the event the matter goes on to court, it also covers that period. So it is wide enough to cover everything. Right. And then when we talk about third-party funder, it's anyone. It could be an insurance company. It could be it's wide enough to cover all parties. Third-party funding is defined according to the bill as means a funding, I will quote, a funding by a third-party funder of all or part of the costs and expenses of the arbitration of the funded party made under a third-party funding agreement in return for the third-party funder receiving a financial benefit. So basically that defines what we already, what Dato had defined third-party funding as. So that is stated now in the bill, which will eventually become a law in Malaysia. Then the other pertinent provision I notice, or which can be gauged from the bill, is with regards to the rule against maintenance and champerty. And why is this necessary? It's obvious for the reason I already stated earlier. We have the Civil Law Act, which makes maintenance and champerty a tortious act. So in order to overcome that, it was decided that instead of amending all the existing legislations we have, we will instead exempt third-party funding in arbitration from being subjected to Section 3 of the Civil Law Act and any other legislation in Malaysia. So for the purpose of third-party funding in Malaysia, it was decided that it would be exempted. It is neither a crime, it is legalized, in other words, okay? It's not a crime, it's not a tort. It is legalized. And another important feature would be the code of practice. So this is perhaps the big chunk of the third-party funding under Chapter 2 of the arbitration bill. So the legal department, it is entrusted to come up with a code of practice. And perhaps this is the reason why the bill has not, or the act has not come, the amendment has not come into force, simply because the code of practice is in the midst of being prepared. So once that is done, perhaps then the minister will gazette the bill. Okay, so the code of practice is basically to govern third-party funders. It is again wide. It will cover everything, third-party funders. It will cover all the necessary areas. It deals with the degree of control that a third-party funder will have in relation to the arbitration, the liability of a funded party, to what extent, termination of third-party funding agreements. But basically, there is a duty to disclose here. Okay, right from the beginning, from the time there is a third-party funder in the picture for either party, the claimant or respondent. Then other criteria or other areas that the code of practice would cover would be the sufficient minimum amount of capital which a third-party funder will need to have prior to becoming a third-party funder. So there is actually a basic criteria in order to become a third-party funder. Conflict of interest that naturally will follow with third-party, between the funder and perhaps more importantly with the arbitrator. So that's an area that can take another session altogether for today. And also the protection to be accorded to funded parties. So all that basically will be covered in the code of practice, which is being formulated now. When we talk about conflict of interest by third-party funders, disclosure becomes necessary. So what is necessary is the code goes the amended. The amendment goes further to determine and state a time frame on when disclosure needs to be made. And this is by the funded party, whether if it's before the arbitration begins, then it should be at the commencement of the arbitration proceedings. If it's midway, then it should be within 15 days. So there's a 15-day timeline. And it's the same even in court. So if we look at the code of practice, I would gather that it's not merely administrative in nature, because it can be, the code of practice itself can be admitted as evidence, both in the arbitral proceedings as well as court proceedings. So it becomes part and parcel of the evidence in the proceedings. However, the However, Section 46E, capital E, makes it very clear that whether there is compliance or otherwise of the code of practice by the funded party, there is unfortunately or fortunately no legal liability imposed on the funded party. Right, but what, of course, the tribunal can, or even the court can take into account is the conduct or the behavior of the funded party when perhaps granting costs. So they could be penalized in costs in that aspect. Okay, there is also a provision on disclosure, specifically on disclosure in the amendment. Which I've already covered. So that would include disclosure by the funded party as well as the intended third-party funder. So this is the disclosure is at different stages. So say, for example, a third-party, a would-be funder is or a party to the proceedings is looking for a third-party funder. They will, of course, need to disclose information relating to the arbitral proceedings. So here we have Section 41 of the Prevailing Arbitration Act kicking in on confidentiality. So the duty to maintain confidentiality remains, and that goes on to the intended third-party funder as well. So whether or not the third-party funder takes up and becomes a third-party funder eventually, the duty of maintaining confidentiality remains. And that's very clearly spelled out in the amendment. And so that includes the prior to third-party funding kicking into the proceedings. And in the event or in the course, if the agreement is terminated, there is also the duty of maintaining confidentiality by the funded party to other parties. And this includes in the event the third-party agreement is terminated. So the disclosure is, so if we look at it, it's not just between the intended third-party funder and the funded party, but the duty to disclose continues with the funded party by making disclosure to the tribunal, by making disclosure to the other party, and if it's the court, to the court. Not only if there is if there is a third-party funding agreement, but also if that agreement comes to an end anytime during the course of the proceedings. And again, when it comes to the duty of maintaining confidentiality as well as the duty of disclosure, there is no legal implication in the event there is non-compliance of the same. However, again, the tribunal or the court can always take cognizance of that fact and take appropriate or make appropriate directions. Right. This brings us to the question, what is the purpose of disclosure? And naturally, it is to ensure there is transparency or openness about third-party funding in the proceedings. Because prior to legislation or prior to this amendment coming into force, there has been third-party funding in this country, but it has been done discreetly. And of course, there is no body regulating it and nothing. So this is just to ensure that it is regulated. It becomes regulated, and I'm sure we in this room we would be divided on whether it ought or not to be regulated. If we look at the explanatory statement to the bill, I found that a little interesting. I thought I'd share it with everyone. It says that the amendment to the current Arbitration Act 2005 is deemed necessary to enhance Malaysia's standing in the arbitration or the ADR arena and to introduce third-party funding through legislation. Okay. So when basically that is all that is covered in the bill, and I believe I have covered most of the areas, unless there is anything else that's all.
Thank you very much, Kiran. I think key takeaway is the fact that, as far as the Amendment Act is concerned, it provides some sort of regulation in two forms. One is obviously from 46 capital A to I, and that is supplemented by the Code of Conduct. That is how Malaysia addresses and very much follows the footsteps of the Hong Kong Ordinance. All right, now that we have heard Hong Kong Ordinance, that speaks of foreign jurisdictions. So then I will take this away and give it to Janice, who will then basically take us through the foreign experience, the selected jurisdictions, to be followed by Janvi. Janice, over to you.
Thanks, Dato. Good afternoon, everyone. Nice to meet you. And Marshall, could I have the slides on? Thank you. If you could go to the agenda. So basically, for everyone's benefit, Jenny and I are sharing the slides. So I'll start first and then Jenny will follow after. I can't seem to see the slides on my screen.
This slide is not on the screen. Probably Marshall could assist in ensuring that the share screen is functioning.
One moment now, we're trying to get it up. Can you see it?
It's not on the screen, unfortunately.
Okay, one moment.
Okay, so maybe whilst they're trying to sort out the slides, I'll just start. As Dato has very wittily said, I wear many hats. Funnily enough, I find today I'm speaking about the Hong Kong and the UK experience, even though I must say I'm a Malaysian qualified lawyer. I have not practiced in Hong Kong nor UK, although I was called in the bar of UK. So just a disclaimer there. What I hear about the UK and Hong Kong experience is generally what I hear from my colleagues and also people in the industry. Okay, so I will just very quickly go through the comparisons of the regulations and then the approach taken on certain issues. And the focus on Singapore item 3, I'll pass it on to the head honcho, which is Jenny. So if we go to the next slide, please. Next slide. Next one. All right, so this is really an overview of the regulations for third-party funding. A lot of words. Could we go back to the table, Marshall? So there are a lot of words on that table. Let me try and simplify that. Yeah. So Malaysia, Kiran has explained it very well. Essentially, we're waiting for the Amendment Act to come into force. It's pending the code of practice, right? So it's a wait and see approach. But what we see in the Amendment Act and the bill is essentially some of the wordings have more or less focused and followed the Hong Kong code of practice and what it entails. I'll go on to the England and Wales experience first. So basically, the whole champity and maintenance thing, it was prohibited until the passing of the Criminal Law Act 1967. Now, interestingly enough, in the UK, third-party funding is governed by self-regulation. So there's no specific regulation as such for the funder, but instead there's an Association of Litigation Funders of England and Wales, ALF. They have a code of conduct and they are essentially expected to follow that and sort out themselves. The Act is quite a thin one. It aims to protect funded litigants, manage conflicts of interest. It has protective measures such as restrictions on termination clauses on the funding agreement and a complaint procedure for the funded litigants. But it is entirely voluntary, right? So only funders who decide that they are going to be members of the ALF are governed by this. And the issue that England and Wales are now grappling with is, should they come up with a more formal regulation? There was a Civil Justice Council report done end of 2024, and the finding in it was that in England and Wales, there are about 44 funders at the moment, but only 16 of them choose to be part of ALF as members. And out of that, only 8 of them are members of International Litigation Funders Association. That means that about 64% are not members of any association, or they are not governed by anything at all, right? It's basically free for all. So that is the issue that England and Wales is grappling with at the moment. Singapore, I'm going to leave it to Jenny to talk about. As I understand, it is basically guidelines, guidance notes, and the Legal Profession Act. Now, Hong Kong, which is the one that Malaysia is following, generally TPF is not allowed, but there was an amendment to their Arbitration Act, which permits TPF for domestic and international arbitration. So the Act for arbitration allows it. There is also a code of practice that have come out, and the advisory board, there is an advisory body that monitors and reviews operation of the code. So question mark whether Malaysia will have a similar advisory body on this. Next slide, please. Marshall, could I have the next slide? Another page and another one. So I'm just going to touch on very quickly on the code of practice. Marshall, could we go back one slide on the Hong Kong code of practice? And the reason why I'm just very quickly touching on this is because Kieran has talked about what the code of practice in Malaysia might look like, right? And actually, the code of practice in Hong Kong does deal with all of these things as well. So if we look at the capital adequacy requirement, a third-party funder, for example, must make sure it has money, right? It must ensure it maintains the capacity to pay all debts when they become due and payable. It must cover all aggregate funding liabilities under all its funding agreements for a minimum period of 36 months. And it must maintain access to a minimum of Hong Kong 20 million of capital. And there are other requirements such as, the reports and the financial reports must be audited. Okay, then we go to the second one, which is the funded party may seek independent legal advice. So very interestingly, the third party funder must take reasonable steps to ensure the funded party is made aware that they have the right to seek independent legal advice on the funding agreement before entering into it. So basically so this is essentially a protection for the funded party, that you know exactly what you are entering into, right? 2.9, that is another big thing for TPF. Essentially, the third party funder is obliged not to seek to influence the funded party or the funded party's legal representative, basically the lawyers and whatnot, on the control and conduct of the arbitration. And they will not take any steps that will likely cause these representatives to be in breach of professional duties, and will not seek to influence the arbitral institution or the arbitration body. So that's the avoidance on influence or control. Avoidance on conflict of interest, basically, there is an obligation not to have a conflict of interest situation come up, and the third party funder should not take any steps to cause the funded party's legal representatives to act in breach of professional duties. Again, these are all safeguards, right, that are going on. 2.8, similar to what Kieran has mentioned, basically there's an obligation for confidentiality. Only certain matters are to be disclosed, and the third party funder is obliged to observe confidentiality and privilege. On the grounds of termination, again, the funder cannot simply terminate the funding agreement and leave the funded party without any recourse. So there are certain matters which the funding agreement must encompass. For example, when they reasonably cease to be satisfied about the merits of the arbitration, or they reasonably believe that the funded party materially breached the agreement, or there's been a material adverse change of prospects. There cannot be a discretionary right for them to just terminate the funding agreement. So again, safeguards on that. There's liability for costs that should be spelled out. For example, when a TPF or third-party funder is liable for, say, for example, security for costs. And there is also a dispute resolution and complaint procedure to be set out, which will deal with if there's a complaint on the third-party funder, how exactly will they deal with these complaints? If I can go on to the next slide. And now I'm going to touch on just certain issues that have come up in TPF. Next slide. Again, quite a lot of words. Just very quickly on the disclosure obligations, Kieran has mentioned when disclosure on third-party funding is allowed. Hong Kong is essentially the same. The point to note is when we talk about disclosure, all that needs to be disclosed is essentially that there is an agreement and that the name of the third-party funder. There is no need to disclose the details of the agreement itself. So something to bear in mind. UK, again, nothing properly regulated, just international rules have mentioned that there should be certain disclosures to be made. On the second item of confidentiality and privilege, Kieran has also mentioned this. A non-compliance of the code will not render the third-party funder to be liable. But of course, this is something that the tribunal can take into account, and especially in taking into account when deciding on costs. So it's a similar situation again to the Hong Kong experience, where one talks about the exception to disclosure where the party is seeking to get funding. There is an encouragement to enter into a confidentiality agreement, but otherwise, the Hong Kong common interest privilege will essentially cover those situations. For the UK as well, the ALF code says that the dispute-related information should be kept confidential. Now, on security for costs, which is the third item, for Malaysia, well, there's nothing quite mentioned in the Arbitration Amendment Act. In Hong Kong, the tribunal does have power to allow for security for costs where there is a funding agreement. And the ALF Code of Conduct for the UK says that the funding agreement should mention when the funder is liable to the funded party to provide for security for costs. On costs in general, in Hong Kong and UK, the position is pretty much similar. The tribunal lacks jurisdiction to order costs against the funder itself, but is able to allow costs against the losing party. And there is a specific case in UK on this called SR versus Norscat. So that's essentially it for an overview of jurisdiction. I'm going to pass it now to Jenny. And Marshall, if you could go to the Singapore section. Dato, anything to add?
I suppose that, we will pass the mic to Jenny, then we could basically then discuss a little bit more subsequently after we have looked at the final jurisdiction, which is Singapore. So over to Jenny without further ado.
Thank you, Dato, and thank you for the kind introduction as well as my esteemed speakers before. Maybe I can move on to the next slide, Marsha. So I'll be speaking on sort of the Singapore landscape in terms of third-party funding. I know in terms of the Malaysian position, it sort of mirrors more of the Hong Kong developments and the changes. But I think by and large, I think the objectives, as I will walk through some of these slides, the objectives, the concerns, the issues, right? And I think specifically to both Malaysia and Singapore, because we have the same sort of underlying legislation, right? Due to historical reasons, obviously, right? I think some of the steps that will be taken, I think will be mirrored by Malaysia, right? In general. So beginning first with legislation. And you will see very soon from the first two slides that I'm going to go through that Singapore, as always, right, very prescriptive, right, and always telling everybody what to do, right, within our jurisdiction, right. So if you look at first the legislation, there is already a mention previously by Kieran, I think, in terms of Malaysia having the Civil Law Act, right. So Singapore has the same thing, right. We have the Civil Law Act, and because of previous traditional reasons, as Kieran had very usefully summarized in terms of the thoughts of maintenance and champerty, right? This is also enshrined within the Singapore Civil Law Act. So when Singapore took the step, right, to say that, we want to now introduce TPF, third-party funding, one of the first steps obviously was to make sure that that thought is abolished. And because that thought is enshrined within the Civil Law Act, so there's an express abolishment, right, or removal of those provisions that capture the thoughts of maintenance and champerty. Now, with that removed, right, the next thing then is to say, right, also similar to what Kieran had said, I think it's already anticipated within the Malaysian development, is that the Civil Law Act that made it clear that certain types of contract, right, will not fall foul of public policy. These types of third-party contracts will be what will be prescribed within the regulations. And that's where the regulations then specifically provide. And the approach has been incremental, right? The approach by Singapore, and I suspect with Hong Kong and UK as well. Well, UK doesn't have regulations, as I understand, but insofar as Singapore is concerned, back in 2017, when they first opened this door for TPF, right, the idea was to open it specifically for international arbitration, right? Not just international arbitration, but international arbitration and proceedings that are related to international arbitration in the Singapore courts. And as well as that, mediation that is related to international arbitration. Now, the reason as to why you open this, some of you may ask, why international arbitration? Why not other, domestic arbitration at that time in 2017? Why not court proceedings in general? I think the idea is that because one of the safeguards previously, one of the reasons why, in fact, there was talks of maintenance and champerty, right, is because one of the concerns was that you have parties who may be at risk, right, of being abused by other parties who have much greater commercial strength or financial strength. That's one of the reasons why. So the idea, I suppose, is that, in international arbitration, what we're talking about are parties that may be more sophisticated, right? Parties who may be, of all better bargaining power between the two, right? So perhaps open the door to have third-party funding into this area first. And of course, and I think also as with Malaysia, one of the other reasons is very commercial, right? In Hong Kong, in UK, you can have third-party funding for arbitration. We want to also make sure that the arbitration landscape, the business sort of ability within the international arbitration is strong. So that's the reason why you allow third-party funding as well there, right? Now, as with Malaysia, and I think Janice had mentioned, the other thing that had to be tweaked was to then specify the types of third-party funders that could qualify, right? It cannot be just anybody. And it again goes back to, we have to take an incremental approach. We can't just allow anybody to become a third-party funder, because the last thing you want is, again, go back to the concerns that we have previously over maintenance and jeopardy, where somebody with a conflict of interest, or somebody who may have certain unethical, right, reasons for wanting to fund, right, the proceedings may come in. So in Singapore, if I can just broadly point out two sort of qualifying factors, would be, one is in terms of the capital, how much they have, to make sure that they can do what they say they want to do. The second thing is also that the third-party funders have to be in the principal business of doing third-party funding. So it cannot be just somebody, doing property, and then it's like, I got enough money and I'm now going to venture into third-party funding. Because there is then that risk where if you're not in that business, you might have ulterior motives in certain proceedings. Right? Again, meant to serve that purpose, incremental approach, open up and make sure that there's only certain types of funders that can qualify. Now, together with the Civil Law Act, as with Malaysia as well, again, there is the Legal Profession Act that I heard earlier on. There had to be changes that had to be made as well to the Legal Professional Act. And in particular, certain things about the obligations to disclose third-party funding. Now, this reason, or this obligation to disclose by the lawyers, is very important, because you want to make sure that if a third-party funder comes in, right, this third-party funder is known to the arbitrator or to the court, the judge, is known to the other side. So in case there may be cases of conflict of interest, in case there may be reason to suspect or justifiable doubts, right, as to the propriety of this third-party funding, the stakeholders, the parties in those proceedings, can raise it. So disclosure is very important. So that's one of the things that was required and specifically amended within the rules itself. And the other thing also is in Singapore, and I suspect it will be the case in Malaysia as well. The law firms that are advising the parties or the funded party, they cannot have an interest, right, in the third-party funder as well, right? So there are certain, it's quite obvious as to why you can't have that, because you want to make sure that there's no conflict of interest, right? So that was one of the some of the things. There are other changes as well, but I won't go into that for the present purpose. But this is just to give you a bit of an overview. So that was back in 2017. What then happened was that 4 years later, in 2021, I think because of how the third-party funding sort of developments were going, they then opened it up as well to not just international arbitration, but they opened it to also domestic arbitration. And also what in Singapore we have is something called the SICC, which is the Singapore International Commercial Court. Now, the reason why you open to, again, these two sort of sectors is largely for the same reason, right? Again, the maturity of the parties involved in those proceedings, and to ensure that Singapore remains competitive as a domestic, as an arbitration hub. Just for your information, SICC deals or has jurisdiction in Singapore to deal with, it's a Singapore court that deals with cases involving international commercial disputes. So once again, you can see, we are talking about parties of an international nature who are involved in a commercial dispute. So those again are people that may not be subject to abuse, right, within a third-party funding setting. Now, perhaps I can move on to the next slide. Now, as I said, Singapore quite prescriptive in terms of how they moved ahead, right? So what happened at the same time in 2017 was that obviously a set of guidelines then came about. Now this, I think, is similar to the code of conduct that both Kieran and Janice had referred to. The sort of things that have been mentioned to be potentially contained in that code of conduct is also similar to what is found in some of these guidelines. So the way Singapore approached it was that the stakeholders who are involved in the set of proceedings, right? So you have your third-party funders, you have your arbitrators, right? And then you have your legal practitioners, right? The lawyers themselves, people who are involved in the proceedings. There are guidelines that applies to each and every one of them. So just to give you a bit of a sampling there, the first one, the SIR guidelines for third-party funders. That's the guidance notes for the third party, the funders themselves, right? So it says certain things about how, in terms of the third-party funding contract, it must be a written contract. It must clearly set out certain things. It sets out certain requirements about financial obligations that the third party must have. It sets out certain points about confidentiality and privilege, how the third party funder, right, even though he's a third party to those proceedings, when he comes in, he should still maintain confidentiality and he must still respect the privilege of information and documents that are provided to them. So things like this, right? One that I would want to emphasize on is on control of proceedings. Practically speaking, I think for many of us, in my experience for the past number of years, when a third-party funder comes in, this is the part that creates the most potential issue as a matter of practice, because you have a third-party funder that comes in, he is the one paying the lawyer, essentially, right? And he gets to have some say as to how the proceedings, right, should go. Strategic decisions, tactical decisions, right, things like this. There is a certain ceding of it, right, to the third-party funder from the client, right? But it is important to set out within the funding contract itself what is the extent of the control of proceedings that can be ceded to. And at all times, and this is important, at all times, the lawyers and the third-party funders must know and respect that the lawyers would always owe their duty of professional duty to the client themselves, not to the third-party funder, right? And if there's going to be any sort of conflict, right, in terms of instructions to be taken, the lawyer would always listen to the client, right? So these are some of the things that are the sort of the guidelines that have been provided to third-party funders. Now, if I go on next to the SIAC practice note on arbitrator conduct. Now, these are then guidance notes. Now, the guidance notes are turning to the arbitrators and now telling them, look, you also have certain guidance notes, certain things you need to take note of, right, when you take charge of a set of proceedings where a third-party funder might come in. Now, it's just a 2-page document, so it's much shorter, and it covers things that I think, both Kirin and Janice had already spoken about, and very much it just talks about how, an arbitrator has to be cognizant, right, of the possibility of a third-party funder, right? So it gives certain powers to the tribunal, right, to be able to order disclosure or to order certain information about the third-party funding arrangement, right, so that everybody knows what's going on, right? I guess the key essential sort of information about the third-party funding will be known to the parties. It also talks about disclosure obligations, which we talked about quite extensively already. And perhaps one that is more directly concerning to the arbitrators is in terms of cost consequences, right? I think Kiran Singh had already mentioned this earlier. So the guidance notes do talk about how an arbitrator in a Singapore seated arbitration can take into consideration, right? Can take into consideration a third-party funding, right? In terms of ordering costs, right? So if, for example, if a party has been funded in those set of proceedings, the arbitrator, and assuming that they are successful in those proceedings, the arbitrator can then take into account the cost that be incurred by the third party, the funded party, right, in making that adverse cost order against the party that was unsuccessful, right? So certain guidance notes of that. And finally, and the most extensive document amongst these guidance notes is the Law Society of Singapore's guidance notes on third-party funding. As always, lawyers, as us, we bear the brunt of most of the guidelines. But fairly speaking as well, that's because, we are the ones dealing, the advocating on the proceedings. We are the ones dealing with the clients, advising them on their rights and the issues that may arise as a result of the third-party funding. And we also potentially may deal with the third-party funders themselves, right? For example, we might even, if allowed to, right, represent the client to negotiate the funding contract itself, right? So in that sense, a lot of the things, because of that sort of interactions that the lawyers would have in those proceedings, there's a guidance notes that talks about things like, when you can when you can make referrals to a third-party funder to your client, but you cannot have any sort of financial interest in that third-party funder. And then in terms of confidentiality and privilege, you must make sure that you advise your clients on how privilege must still be maintained when you speak to a third-party funder. All these things, right, is a lot more extensive with the lawyers involved, and the guidance note serves that purpose. Can I move on to the next slide, Marsha? Okay. I've already covered this earlier on. As I was saying, I think the concern that is it's important to make sure that it is not going to be just anybody that comes in who says they want to be a third-party funding, who is rich, who can do it, right? Two of the important criteria, as I said earlier, principal business, enough capital. The first point I suspect is largely to do with, making sure that the third-party funder that comes in is legitimately interested in funding the process, right? And no other ulterior motive. The second one is to make sure that they are in fact able to do it, in fact able to achieve the purpose of funding the proceedings. That's all. Next slide. Hi, Marshall. The next slide, if I can. Now, the next few slides actually talks about what have already been covered quite extensively by all the speakers before me, and I've also already mentioned it. Issues like confidentiality and privilege, the reasons for why you need confidentiality and privilege. If you think about it, it is actually quite obvious, right? You just need to make sure that if a third-party funder comes in, who is a third party, you don't lose the privilege. It doesn't mean that, once a third-party funder comes in, once you disclose it to a third party, then information, tactical instructions, all these kind of things will become lost. It will become disclosable to the world at large. So that's the importance, and that's why there's a lot of importance in terms of the obligations and the requirements there. If I could move on to the next slide, I'm distinctly aware that I'm hitting 6:30, right? And everybody is probably thinking about dinner already. So I will just try and run through the remainder slides as soon as I can. Okay, this one, maybe I'll just stop on this, pause on this for just a few seconds. Influence and control over proceedings. I've talked about it earlier, and I can tell you that this is the one that, practically speaking, you can get a third-party funder to come in. This is the one that practically you should give some further thought to it. How much of it should this third-party funder be able to be involved in those proceedings? And it is a matter of choice. If you look at the law SOC guidance notes, right, it does provide certain guidelines, right, which can be useful, right, if you were to enter into a third-party funding contract. Have a think about it, right, and just be careful about how, and try to think ahead in terms of the proceedings and how you might want to manage this together with the third-party funder. The last thing you want is to have a dispute, right, with the third-party funder as to how to manage the matter, how to instruct your lawyers. And so I will end off by also saying that in the third-party funder contract, another practical point to consider is to have a provision, right? I will call it a dispute resolution provision, right, to deal with situations where if there may be a deadlock, right, in terms of how to manage things in the third-party funding arrangement, have a provision that's carefully crafted, right, to say how parties can deal with it in the event of a dispute between the parties. Right, with that, perhaps I will end off on my session, and thank you again very much.
Thank you, Jenry. You've hit it just 20 seconds before 6:30. We are still within time. So if I could just basically summarize what the discussion is all about. I suppose that third-party funding is here to stay. And obviously, all of us will agree that, it's a boon and a bane at the same time. And the challenge is how to regulate it. As Genvi says, Singapore take a forefront action by being prescriptive to the extent of being boring. And, it's basically prescribing obligations on all parties to the arbitration, the councils, the arbitrators, the third-party funders, and also the claimant and the respondent. That is the method and which is typical of the Singapore. As we have actually heard, UK is more laid back, and obviously so as in Hong Kong. Whereas in Singapore, it's a bit a world of a difference. I suppose we could extend for 5 minutes if we've got question and answers. Well, any participant who's got a question may raise their hand, and we could basically deal with the questions. Anybody, anyone? Going once? Everybody is shy, or like Genvi says that, the thought of dinner is too tempting, then it cuts away all the questions that may have in the beginning of the discussion, that all fizzle out and all that. If you don't have questions, probably I'll invite some concluding remarks from all the three distinguished speakers. Probably we start with Kiran first. Anything else that you wish to add?
Thank you, Dato. Just to conclude, I do hope that areas that have not been covered in our arbitration, the amendment bill, will be covered in the code of practice. This will include issues such as costs, which I believe Janice touched, as well as Genway. Singapore has it, UK has it, but we may need to look at that. And other moot areas like conflict of interest, whether the IBA guidelines on conflict of interest for arbitrators would be necessary. That's all from me, Dato. Thank you.
Thank you. Janice?
For me, I guess it's a lot of question marks at the moment because we're not sure how Malaysia is going to go about it. We don't know what's in the code of practice. We don't know whether there's going to be an advisory body. I think the air is a bit of apprehension when I speak to people, right? Some people say, hey, it's a great thing, you know, it's going to increase access to justice. And other people are worried that it could potentially, you know, increase the floodgates or open the floodgates. So it's kind of a wait and see process. But I think the good thing is we do have guidelines and guidance from other jurisdictions. I love the way Genwy has talked about the Singapore position and approach, and basically what are the factors to consider. So I think this is something that we all need to grapple with going forward. Thank you.
Thank you, Janice. Genwy?
As
usual, we will give it to Singaporean to have the concluding remark.
I should say for the record, it's not boring. This whole position is not boring. It's very exciting, very positive, right? But to stay true to my word, I told everyone else to go for dinner. So, you know, I think the comments already made by Kiran and Janice is more than enlightening. So with that, I have no further points to make.
Well, thank you very much, everybody. On behalf of BICAM, let me thank everyone for taking the time and the trouble to basically appear today and join us in this discussion. Thank you very much. I suppose that, you know, I'll turn this over back to the organizers for them to do the closing. Marshall, it's back to you. Thank you, Kiran. Thank you, Janice. And thank you, Genwy. Everybody has a nice evening. So
thank you, everybody, especially our panelists for attending today, for giving the talk, and for those that attended, thank you for tuning in.